The surety is the assurance given. The principal debtor is the person who is selling, and the principal creditor is the person who is buying. Whenever you are writing the assurance law, it is going to be written only in the English law. Section 128 of the Indian Contract Act states that liability of surety is coextensive. Good morning and welcome to the third session in Unit 3 Commercial Law B.B.A 4th Sem, where we are going to talk about the contract of guarantee. Now, what is guarantee or the contract of guarantee all about? The Section 126 of the Indian Contract Act defines contract of guarantee as a contract which is to perform the promise or discharge the liability of a third person in case of default. Now let's try to understand this word very clearly. Guarantee means that I am trying to give you something in promise. I say that when you buy this pen, when you buy a laptop, when you buy a mobile, I'm giving you guarantee. I'm saying that this will not break. I'm trying to give you an assurance altogether. But in case if my words are not true, if my words don't stand back, that means I need to compensate back for the words I have told. So guarantee is like a stand back promise altogether. Now let's go here and try to understand the guarantee in detail. The person who gives the guarantee is called as the surety. The person is also called in terms of the guarantor. Why? Because in respect to the defaults of the guarantee is called upon the principal debtor, and the person to whom guarantee is given is called as the creditor. Let us try to understand here the words very clearly. If I am going to give guarantee to you when you are going to purchase something from my shop, then I take the moral responsibility of giving that goods to you, saying that the goods are in proper condition. In case if something goes wrong with that particular good, it is my responsibility to replace it back or give you the compensation. The person who is taking the guarantee on the other side becomes the creditor. Why? Because I am indebted to the customer. In case if there is a mistake, I have to repay, I have to compensate back. So that is why I bring in this word called as the guarantee. There are three parties in each guarantee: the contract, principal creditor, surety, principal debtor. Here, why? Because I want to go about here in this fact. The contract has got three factors: the principal creditor, surety, and the principal debtor. So the surety is the assurance given. The principal debtor is the person who is selling, and the principal creditor is the person who is buying. Now, moving further, the three contracts factors. Now, the guarantee contract, as I said, there are three factors involved here. The first, principal debtor himself makes a commitment saying that I shall fulfill as per the needs and requirements of the given product. So that is where he is giving in the contract factor altogether. He is giving in the guarantee, saying that when you are going to buy this from my shop at the given point, at a given instance altogether, no need to worry, I am giving you the guarantee here. Now, second, if the principal debtor makes a default in the surety undertakes to be liable from the creditor side. So suppose if I make a mistake, I am not able to keep up to the words of the guarantee given by me, the surety will be taken care of, undertakes to be a liable part to the creditor. Thirdly, the principal debtor's implicit promise. What is this called as? Implicit promise. Why? Because it is already taken into consideration. It is very well built in within the contract. When I say explicit, that means I am expressing it outwardly. But when I say implicit, that means it is already inbuilt in the promise altogether. So that's why I say that it's an implicit condition altogether to support the assurance that the event of the protection is obliged and discharge the responsibility of the principal debtor's default. The principal debtor shall immediately indemnify the protection. So that means immediately the person who has sold the goods to the customer shall go ahead and repay back, shall compensate, shall take care of the situation. That is what we mean here by guarantee. Why companies today pay a lot of attention in terms of understanding this guarantee is because they know that when they are placing the goods, they are placing their brand, their image, and most importantly, the trust factor. So suppose if they are not able to keep up the trust, suppose they are not able to give that surety, they are not able to run the system without that trust factor, automatically for the customers it becomes very, very difficult to go forward and take it. They might doubt the product altogether. So that is why what happens here is that the companies give a guarantee, companies give a warranty time period, they give a factor altogether saying that this is what is the company's standby altogether, this is where the company stands by its words. So that's why guarantee forms a very, very important factor in terms of our business contracts. Next one. Now we need to understand the main features. The main features here are contract can either be oral or in writing. So it's both verbal as well as written on the paper. So the first thing that we need to understand here, it can be oral or writing. So even verbally, if you have gone ahead, promise somebody that this particular product is under guarantee for the next 6 months, next 1 year, whatever the time period guarantee given, then automatically it is considered to be true. And it is also equally good when you are giving it in writing. Nevertheless, assurance contracts can be only written in English law. Why? Because it was formed under that particular condition. So whenever you are writing the assurance law, it is going to be written only in the English law. You cannot go ahead and write it in any other format or in any other situation. The guarantee contract presumes that a principal liability or discharge duty on the part of the principal debtor. Very, very important factor here. Why? Because it tells very clearly that whenever we are talking about this guarantee contract factor, it talks about the duty of discharge on the part of the principal debtor. The principal debtor is very, very important. Even here, there is no such principal liability. One party, that is I, agree to pay under such situation, and the enforcement, whatever I have told that I will repay back in case of damage, in case of any things that is not been under proper condition, shall be an obligation here, and it's not contingent on anyone else default. It is an indemnity contract, so it is bound automatically. If I am not able to retain my words which I have given regarding the product, regarding the service, I have to repay back, I have to compensate him. So that's where we say that this is like an inbuilt contract altogether. So it is very much taken into picture that we have to understand what are all the factors that are already implied inside. Suddenly, if you go and say that I do not know, then the customer is not going to believe you. So it is always important that we first understand what is the product, what are we promising to the customer, and why it needs to be taken in such position. followed by sufficient consideration to support the principal debtor. Very, very important. It is not necessary to have clear consideration between the creditor and assurance is that appropriate creditor has done. For example, when I'm trying to put these words very, very clearly to you, it says that appropriate, that the creditor has done anything for the good of the principal debtor. So it is very, very clear that in case whatever changes, whatever damages that are being spoken, there are sufficient consideration to support the principal debtor. So only if the goods are found to be in a particular condition where it has been told as per the contract, then we talk about the guarantee. It is not necessary to have clear consideration between the creditor and the assurance that it is appropriate, and it's not always mandatory that the creditor will win the case. It is also important to see under what terms condition the good is being taken into the warranty position altogether. So it becomes very, very important here to read the assurance words, what is being written there. That is mandatory in terms of understanding. Assurance consent cannot be obtained by misrepresentation. So please keep this in mind. You are not going to get assurance by misrepresenting or cover any material information in relation to the transaction. If you try to hide, if you try to cheat, if you try to provide any information that is false, then automatically the contract of guarantee shall be held null. So it is very, very important for you that you don't hide information. Why this is important, let me again stress upon, is that whenever we go to buy any product, please take time in terms of understanding the product by unboxing it, understand each and every feature, and when you go through the guarantee slip, please understand what parts, why it is guaranteed, under what circumstances. You cannot go back after some time and say that, sir, this part is broken, you have to replace. Suppose that is not a part of the assurance contract, then the creditor or the customer cannot get his guarantee back. So it is mandatory. We first read what is being provided and then we can go into the assurance factor. Liability of surety. Now, this is a very, very important topic. As per section 128 of the Indian Contract Act, states that liability of surety is coextensive. It is coextensive, which I mean to say that it is extended with the principal debtor unless and until it's otherwise provided by the contract. Now, when you are taking a contract of guarantee, it is by default understood that the surety part lies with the debtor, that's with the shopkeeper or the owner who is selling the product or service. Unless and otherwise, suppose in the contract it is mentioned, sir, the shopkeeper or the owner is not responsible, it is the company or somebody else, then only the contract will be written otherwise. Or else it is understood by default, it is always with the owner of the shop. So the principal debtor is none other than the person who is involved with the liability of surety, followed by the surety's liability is the same as that of the principal debtor also. So principal debtor is also involved. A creditor can move directly against the surety. So he can move against the surety without suing the principal debtor, without even touching the principal debtor. A creditor may sue the surety directly. So a creditor might directly go ahead and say that, sir, you only had told about this product, which will work like this, it will be like this, you had given the assurance, but today the product is not working, the product is not up to the mark, so I have the rights to go back and sue you in the court of law, because the creditor has the direct rights to sue the surety directly. It is liable to make a payment immediately after the default of any payment of the principal debtor. So automatically, if there is going to be a default coming into picture, the surety of liability will have to compensate back The customer saying that, yes, because of this mistake, because of these factors, we are giving back, we are compensating you as per your request, as per your order. So that is why the liability of surety is very, very important for us to understand. Now, primary responsibility for making a payment is, however, is from the principal debtor, and the responsibility of surety is secondary. This is one very, very interesting factor. The assurance, what we are talking about today, is a secondary factor in the contract. Why? Because it's a statement. The assurance comes in as a factor, as a matter of thought process, is secondary in nature. What is coming primary in nature, that is even more interesting for all of us to understand. Why that is even more interesting for all of us to understand? If you look here clearly, it states very, very clearly, very factually, categorically, it tells about this factor that the principal debtor becomes the first person who is involved in the debt matter. So what is going to do is that he is the person who is going to get into the activity. He is not going to be a third person altogether. He is going to be the person who is going to get involved at any given point of time. So he cannot go back and say, sir, I don't know. I did not know about the principal. You are the liable person, so you are going to pay the liability. The surety is only going to come secondary as an add-on factor. It's the principal debtor who has to make the payment. In fact, if the principal debtor cannot be held liable to the payment because of any documentation, because there is a factor that says that, an evidence that comes back and says it is not the principal debtor, then responsible for such payment as well. So that means to say that if there might be any documentation error coming into picture, then the surety is not responsible. If it is mentioned in the documentation or there is some mistake in the documentation, then the surety is not held responsible, or else at the first level it is the principal debtor who is responsible for the payment altogether. Now, the rights of surety is broadly classified under these factors. We will start with the principal debtor, the right against the principal debtor, against the given notice. Then we are going to talk about the subrogation. Then we are going to talk about indemnity. Then we are going to talk about securities. And then we are going to ask for the relief factor altogether. So we start against the debtor first. We need to understand what is the right against the debtor, then against the notice. Then we are going to talk about the rights of the subrogation. Indemnity factor, how is the indemnity of this contract coming in? Securities factor, and for the relief. When I use the word relief, it is like basically getting back what sort of compensation altogether. Now, the next thing is that we also talk about the creditor, right, to get against a security, ask for a set-off. When I say a set-off, it is being taken off the books altogether. Let's look for a outside the court kind of settlement here. Subrogation, which is again coming into picture. Advice to sue the principal debtor. Now I am not getting my money. Now I am not getting what is being told. So I am going to sue the principal debtor. Termination of services. I don't want this service at all. So there also I will have my rights altogether. So when you go through this contract, you will be able to understand that there are several factors which are inbuilt, which are taken into nature, that has to be considered very, very clearly before we start actually putting into the contract. But if then we are not done it, or if we have not taken it into account, then this becomes a very, very serious problem. Now, rights against the co-sureties. Right to ask for contribution. Surety can be asked on the basis of which, where we need to add the sum where the principal debtor defaults altogether. If they have issued commitments for equal quantities, they would have to make for an equivalent contribution altogether. In the event that the guarantee is given to equal quantities. The contribution style varies from England law to the to the Indian law altogether. Right to ask for contribution. What is the meaning of contribution? Can ask, that is, for example, surety can ask its co-surety, that's the debtor, to add some when principal debtor default. So now they will say that, sir, in case if that person is not able to pay back, there is some way where you need to add some money to pay back to the customer. If they have issued commitments for equal quantities, that means they have to make equivalent contribution. So surety as well as the co-surety person have to make equivalent contribution. This is very, very important. Why? When we talk about surety, whenever you sign on the bank document surety for somebody else, that means you also equally become liable for the debt taken from the bank. So suppose if the first person defaults, the co-surety, the surety person also have to be taken into account and pay back the money altogether. So that's why it becomes very, very important. According to the England law, payment in the ratio of assured sums to be made. Nevertheless, according to Indian law, the sum of deficit to be allocated must be equal to all guarantees. That should be equal to all guarantees, and each promise must contribute a share of deficit pledge, that whichever is lower. So you have to make a contribution where it says that nevertheless, according to Indian law, the sum of deficit that is to be allocated must be equally to all the guarantees given, and each promise must contribute a share of deficit pledge at the end of it, whichever is on the lower side. We are not going to ask you on the higher side. So whatever is on the lower side has to be pledged, has to be given altogether. Now, we are also going to talk about right to claim share in securities, which means to say that continuing guarantee, where we are looking in one form of guarantee that extends to the series of transaction is continuing guarantee, which means we continue to provide guarantee. It goes in like a series of activity. A continuing guarantee extends to all transaction that the principal debtor enters into before the surety revokes it. That means until and unless the surety factor is there, it's inbuilt, the principal debtor is also involved. If the surety document or the surety factor comes in and says that only to this extent it is being taken care of, then we don't have to worry altogether. So that is what we are talking about in terms of the continuing guarantee. The next thing is that a continuing guarantee for the future transactions may be written or withdrawn at the time by the notice of the creditors. So who are going to be there? That creditors are going to say that for the future transaction we don't want it, we can withdraw it. That can be done by a written statement by the creditors. However, the responsibility, who is going to take the responsibility of surety of transaction completed or the revocation of this guarantee is not diminished. It cannot be reduced unless and until, that's what we try to say, responsibility, which means somebody who is going to take the responsibility of surety of transaction completed prior, which is already done before, to such revocation of guarantee is not diminished. It cannot be reduced. It still continues to hold value. So guarantee is something which can be limited in nature or which can be continuing in nature. But if it continues in nature, that means the principal debtor is also there with us in action as per the necessity. It continues, it goes on altogether. Followed by discharge of a surety. How are you discharging the duty? By providing a revocation notice for future transactions. So that comes under section 130. The guarantee is revoked, which means it's taken off. No more guarantee for the future transaction under circumstances. In the case of death of the surety, suppose the person dies, then how are we revoking it altogether? Section 131 is the factor that we are taking into account. When there is a non-consensual change, that is non-consensual change coming into picture in terms and conditions of the contract, in terms and conditions of the contract between the creditor and principal debtor. That means creditor and principal debtor today are not agreeing. They are not in good terms. They don't believe each other. They have some problem. The trust is broken. Then automatically the surety is revoked altogether. Now, again, continuing with the discharge of surety, we also say that in the case creditor releases the debtor or makes any such omission which results in the discharge of principal's liability. Now, the creditor himself gives away, sir, I don't want it anymore. It's gone. We are finished with the case. I don't want to see you again. I'm not interested in doing this business, or I'm not interested to include you anymore in any of the contract, written or in verbal form. Then automatically the creditor releases the debtor away. He says that we don't have to talk about it anymore. So this is done and dusted. So we are not going to get into the contract again. When complete payment is made by the principal debtor. Now this is a very simple case where I go ahead, I complete my payment, there is no problem at all. Now the creditor releases me, says that yes sir, you have completed all your payments, no need to worry anymore. So it is done. Followed by the surety is also discharged when the creditor enters into an arrangement with the principal for not to sue him or to provide extra time for the payment of debt. This is being told very clearly in section 135. Now look at this clearly. It's also discharged. Surety is discharged when the creditor enters into an arrangement with the principal debtor for not to sue him or to provide extra payment time, so not to sue him or to getting into any kind of extra payment for the repayment factors altogether. When the creditor does any act which is inconsistent with the rights of the surety. If the creditor tries to do something which is not consistent with the contract, which is not consistent with the system at any given point of time, then automatically it is a discharge of the surety happening. Exceptions to the discharge of the surety. Now this is very, very important. Why? Because the surety cannot be discharged if the contract to provide the time of principal debtor is not made by the creditor within the principal debtor but with the third party coming into picture. It cannot be discharged. Why it cannot be discharged? If the contract to provide the principal debtor is not made with the creditor, with the principal debtor, but with a third party altogether. Suppose you bring in a third party here, then it's automatically a discharge, a revocal of the surety altogether, because it's not made with the first person, but it is made with the third person here. In the case of a co-surety, if one is released by the creditor, the others do not stand a chance. It has to be released on both the ways. So that's why I say here, the creditor will have an upper hand. He has to give in writing verbally saying that all the people who are involved, the surety and the co-surety, are released out. Then only they can come out of the documentation, they can come out of the picture altogether. Until and unless they will be held liable in case of default. Now, the next thing is that difference between the contract of indemnity and contract of guarantee. There are two parties in the contract of indemnity, whereas contract of guarantee will have three parties. So, the first case we will have two parties, in the next case we will have three parties. Then the next thing is that three contracts exist in guarantee. So, there are three contracts while there is only one in the indemnity factor altogether. The liability of indemnifier, when we start looking, is the primary in that area, whereas in the contract of guarantee, the liability of surety is secondary and primary liability is the debtor himself. So this is the difference that you need to understand. Followed by contract of indemnity. When you say that, it serves the purpose of whom? Saving the other party from suffering any losses in case nothing should happen to him. So that is why we bring in this. But here the guarantee itself is that to assure the creditor that the contract will be performed. There we are looking for the other party. Here we are looking in for the creditor himself not to get affected. Now the liability in contract of indemnity arises only when a specific condition, contingency occurs. But in the contract of guarantee, the liability is already there. Moment you have sold it, that itself you are there in the liability factor. Whereas in indemnity, only if there is a contingent situation, only if an emergency situation crops up, then we are going to talk about this. The promisor cannot file the suit against third person in the contract of indemnity unless the promisee relinquishes his right in favor of the promisor, whereas the surety does not require any relinquishing here in factor because it's filed already there as per the contract. The surety has to pay in case of the default happening. There it is not like that because he cannot directly file a suit, but here the surety or the creditor can directly go ahead and file the case. Now bank guarantee, this is another form of thing which is very, very important. Bank guarantee is a tripartite agreement between the bank receiver and the individual client altogether, where a bank gives an undertaking to pay the receiver for a definite amount of money and arranges the fulfillment of customer's obligation in the case of his default. Now, what do normally banks do? Bank will provide a loan to the customer saying that, yes sir, we will give you a loan according to your need. We will do the valuation against a security, against an asset altogether. It's a tripartite. Why? Because there is a banker, there is a customer, that's a receiver factor, and the individual or the client factor here. Now what happens normally? Banks are usually approached for having the financial resources to meet at any given point of time the obligations that have been told. It is it's a simple kind of absolute obligation that has to be taken care by the bank, and it has to pay back the balance. Suppose you have to pay back the balance in case if the guarantee holder requests for it. So at the end of the day, you are supposed to pay back the amount taken up by the bank. Whatever is the factors that have been told by the bank, you have to repay back the entire money. Now, the next thing is that it's an arrangement between the beneficiary and the creditor who is distinct and separate from the underlying contract that insists. So that is where you have to think about it. It is particularly relevant when assessing the bank's responsibility in the event of debtor default. So in the event of a debtor defaulting, then this comes into picture. It is simply for the free flow of trade, as the guarantee provided by the bank, it protects the borrower from the loss and also gives the borrower, the person who is borrowing money, the right to claim the debt in the event of default without going through the tiresome and prolonged process of litigation, prolonged process of going through the case. So if you understand, it's a free flow trade of the guarantee by the bank. It protects the borrower, the person who is borrowing money, from the loss and also gives that person a right to claim the debt. You can go back and put a case against a bank saying that claim the debt in the event of default without even going through the legal obligation. So that's where the bank guarantee becomes a very, very important factor. So tomorrow when you have put a fixed deposit in the bank and the bank does not return you or promise to return you back on the time, the person, the borrower, can go ahead and put a case against the bank saying that you have not been able to repay bank the money, so that will go into a legal situation altogether. Now, there are two types of bank guarantee that we are going to talk about. Advance payment guarantee. Now, what is an advance payment guarantee? Which means to say that buyer of goods and commodities generally use this type of guarantee to secure and protect the advance payment that they have made in exchange of the goods. So whatever that they have taken it, they're going to buy it and they're going to make an advance payment factor there. Advance guarantee can be paid to recover, as it is the primary obligation. It's not just one person, it's a primary obligation of the bank which is giving a guarantee. So in the bank will say that on the behalf of the client, I shall go ahead and make the payment on the time that is required. So it's an advance payment guarantee which is made by the bank so that the goods and services reach the client on time. Followed by payment guarantee that we are talking about. It is more of a secured form of guarantee that makes it compulsory for the debtor, for the bank to pay. So moment when the bank says that the FD will mature on the 6th of August. So 6th of August, they have to make the payment altogether. So that's what we talk about, the payment guarantee. With this, I come to the end of this particular session. I hope and believe that all the information that has been shared here will be of a great help and resource to you. In the upcoming sessions, we shall see more about the commercial law in terms of the rights altogether. Until then, stay tuned, stay blessed, and stay enlightened forever. Thank you once again for joining me today on this wonderful session.